Thank you so much, Fiona, for the introduction, and to Bruce. Like I say, I'm Juliet Harris. I'm director with Together, the Scottish Alliance for Children's Rights. And I'm just delighted to be invited to speak to you this morning at this fantastic conference. It's such a perfect time to be talking about children's rights in law and to be reflecting on how we secure justice for all our children and young people. Because like Bruce has said, like the Minister has said, UNCRC incorporation really does give us the power that we need to try to make sure that children in conflict with the law experience their rights all of the time. I'm aware of the fact that Together's not the most well-known of charities, and so I just wanted to provide a little bit of an introduction as to who we are at the beginning. We're an NGO alliance of over 450 members, and we all share a vision that we want to see all children and young people in Scotland growing up with their human rights respected, protected and fulfilled all of the time. Our membership is really wide and diverse. It includes CYCJ, it includes large international charities like UNICEF and Save the Children. It includes after-school clubs, it includes social workers, it includes some schools. If you're not a member of Together, I would encourage you to join. I have included a link to our website at the bottom. I would encourage you to join because it's just a way of being part of a really big, exciting community who we're all working to inspire and enable everybody in Scotland to put children and young people's rights at the heart of what they do. So if you're not already a member, please do join us and really help us to pursue this vision, help us to create a Scotland where all children and young people experience their rights all of the time. I want to start really by looking back at exactly 3 months ago today. Because it was 3 months ago today that we celebrated Scotland just taking such a significant step closer to what the Deputy First Minister described as a revolution in children's rights. So it was on the 16th of March 2021 that the Scottish Parliament unanimously supported the incorporation of the UNCRC into Scots law. The Minister for Children and Young People at the time, Marie Todd, said that UNCRC incorporation would mean that children's rights would be woven into the fabric of our law, our policy and our public life in Scotland. She went on to say that children will have the right to be involved and heard in decisions that affect their lives. And importantly, she said, this means we will all need to act to change things. Just want to remind everybody here, she also said, when budget is required to support services that enable the fulfilment of children's rights, it will need to be provided. So this is Scotland's commitment to really invest in children's rights, invest in children, and make sure that those children who are more likely to be left behind aren't left behind. This is for all children and young people. The revolution in children's rights has support from every party in the Scottish Parliament. It was welcomed by the Scottish Conservatives, the Liberal Democrats, the Greens and Scottish Labour. In her penultimate speech to the Parliament, Mary Fee of Scottish Labour said, "In leaving this Parliament, the best parting gift I can give is empowerment, protection and respect to all our children and young people through the passage of this monumental bill." And so that is why we were celebrating. We were celebrating empowerment, protection and respect. That was our vision. That is our vision for all children and young people in Scotland. It wasn't just the Parliament that was celebrating 3 months ago. The bill was widely welcomed by children and young people who had been campaigning for UNCRC incorporation for decades. So long now that actually many of the children that I've campaigned alongside are now adults. Abigail, a young advisor from the Children's Commissioner's Office, said that children and young people will now feel safe in the knowledge that their rights are in law. She described incorporation as a way of children having their voices heard. They know that they will be listened to and they know that they matter. And I think that's absolutely key for children in conflict with the law. This is what we want for children in conflict with the law. We want them to know that their voices will be listened to. We want them to know that they matter. It was such a significant moment for Scotland. I mean, social media was absolutely buzzing. Buildings in Edinburgh and Glasgow were lit up for days in UN blue. Members of the UN committee joined children and young people to dance and play with them on Zoom. You can see many of the photos here of children, young people, parliamentarians, committee members, all celebrating this significant moment on Zoom. And we were celebrating because we have this vision of a Scotland where the rights of all children and young people are made real all of the time. But we have to ask, what does the bill actually do? And what does it mean for children and young people? And what do we need to do to make sure that this vision we have becomes a reality for children in conflict with the law? Despite Scotland being bound by international law through the UK's ratification of the UN Convention on the Rights of the Child, children's rights have only been guiding on governments so far. So they've been kind of something that government, Scottish government, local authorities, other public bodies need to really think about rather than do. And the UNCRC Incorporation Bill changes this. It makes children's rights binding on all levels of government. And so this means children's rights have to be at the centre of everything that we do, from education to health, to policing, to social work, through to transport and even the environment. In the most serious of cases, if children's rights are breached, children will be able to complain to the courts. Scotland isn't the first country to incorporate the UNCRC into law, so we have experience of other countries to look at. We know from countries that have already incorporated the UNCRC that legal incorporation matters. Those who have gone before us, Belgium, Norway, Iceland, Sweden, Spain, they report that one of the biggest impacts is actually culture change. These countries are more likely to perceive children as rights holders and have a broader respect for children and for children's rights. In incorporating the UNCRC into law, it's been called an influential touchstone for all those whose decisions impact on children across legislation, policy, and practice. In this sense, the kind of proactive elements of the UNCRC bill that I've included in this slide here help to safeguard children's rights by preventing breaches of children's rights. But whilst the proactive nature of incorporation can help to minimise the likelihood of children's rights being breached, this risk will never be completely removed. And so the second part of the bill, the ability to challenge breaches of children's rights, is actually the most essential part of the bill. There are provisions here that enable children or their representatives to challenge breaches of their rights in the courts, and also for courts to assess whether law is compatible with the UNCRC. Many children have said that speaking out can be difficult. They may not know about their rights, or they might not know what to do if their rights have been breached. I think for children in conflict with the law, the balance of power can make this particularly difficult. And so there are provisions that enable the Children and Young People's Commissioner to bring or intervene in proceedings, and these are absolutely key. As is the ability for those organisations with sufficient interest to be able to bring cases on behalf of children and young people. I think a particularly important aspect of the bill as well is that it applies to all children and young people under the age of 18 years old. This is a significant step towards addressing the inconsistent definition of the age of the child in Scotland that can leave 16 and 17-year-olds, particularly those in conflict with the law, without adequate protection of their UNCRC rights. So the proactive elements of the bill, combined with the ability to challenge breaches of children's rights, create a very powerful tool, as Bruce has said, the most powerful tool that we can use to achieve the vision that we're all trying to make real. But I think it's worth again taking a step back and reflecting, what does a rights-based approach for children in conflict with the law actually look like? A rights-based approach to children in conflict with the law must make sure that children are not unduly criminalised or stigmatised as a result of their behaviour. Instead, children must be supported to address their behaviour and to rehabilitate. A rights-based approach recognises that children who come into conflict with the law often have significant underlying needs, and a failure to address these needs is actually a violation of their human rights. A rights-based approach takes into account as well the need to ensure public protection and to acknowledge that the harm that can sometimes be done caused to others by a child's behaviour. I think it's worth really reflecting on the 4 general principles of the UNCRC and those articles within the convention that make specific reference to children who have come into conflict with the law. So on this slide here, I've outlined what the 4 general principles are. Looking at the first Article 2, which is non-discrimination. This means that all children in conflict with the law should be given equality of opportunity. So to do this, we must pay attention, particular attention, to those children who might need additional support. So children with a disability, perhaps those with communication needs, or those with mental health needs. The next general principle is the best interests of the child. And this must be at the heart of all decisions relating to children in conflict with the law, both in terms of those children who exhibit offending behaviour and those who may be child victims. To protect the best interests of the child, rehabilitation and restorative justice must be at the absolute heart of everything that we do here in Scotland. Article 6, the right to life, survival and development. This reflects the fact that coming into contact with the youth justice system can have a seriously negative effect on a child's development. Detaining children can have very negative consequences. It can seriously hamper their chances of reintegration into society. So the whole youth justice system must support children's development. And this doesn't mean just supporting them to survive, but actually doing everything we possibly can to help them thrive. And finally, Article 12, the most well-known general principle, the right of children to not only express their views, but for their views to be taken into account in decisions that affect them. This must be fully respected and implemented throughout every element, every process of the youth justice system. So these are the 4 general principles. I think it's really worth always having those at the forefront of your mind in any decision, any conversation that you're having around children in conflict with the law. Ask yourself, what do children and young people think about this? What are children's best interests? Are we making sure that there's real equality of opportunity for all children and young people? And what are we doing to support children to thrive? The other 2 articles that I particularly want to flag up, I know I've got 3 there, but the other 2 that I really want to flag up are Articles 37 and 40. 37 is around the right not to be punished in a cruel or hurtful way. And so Article 37 is clear that no child shall be punished in a cruel or harmful way. No child should be unlawfully detained. Detention should only be used as a measure of last resort and for the shortest appropriate period of time. And every child who's detained should be treated with humanity and with dignity. And that's a really powerful, powerful part of the UNCRC and just so important for children in conflict with the law. Article 40 is around children's rights and juvenile justice. And it's very clear that there should be specialist systems in place for children in conflict with the law. It includes the obligation to establish a minimum age of criminal responsibility and to put measures in place to divert children from formal judicial processes. Importantly, Article 40 sets out the right for children in conflict with the law to be treated in a way that is consistent with the child's sense of dignity and self-worth. This right to dignity and worth must be respected and protected throughout the entire youth justice system, from any contact that children might have with the police, through to every element of the youth justice system and any further support put in place for a child who's been in conflict with the law. And I think it's essential that we all reflect on this emphasis on a child's sense of dignity and worth. If, like me, you're not a lawyer, and sometimes, or perhaps often, you feel a bit intimidated by the idea of understanding all the specifics of laws and regulations, then I think a child's sense of dignity and self-worth is a key to everything. What better way can there be for anyone to know if something is rights respecting than considering whether or not it supports a child's sense of dignity and worth? When I think of dignity, I always think of a Children's Parliament project where they invented a dignometer. It's a bit like a barometer, but rather than forecasting the weather, it actually forecasts the impact that something has on a child's sense of dignity. And this is the Children's Parliament's dignometer. So children from the Children's Parliament use the dignometer to identify things that have a positive impact on their feelings of dignity. Things like having a voice, being listened to and taken seriously, being protected and cared for, having shelter, feeling safe, getting extra help when they need it, being encouraged and feeling supported, and even people saying that you're good at your hobbies. Children from the Children's Parliament use the dignometer also to identify things that have a negative impact on their feelings of dignity and self-worth. Things like being cold and hungry, being discriminated against, being poor, being homeless, and people ignoring your ideas. So in this way, a dignometer helps to forecast whether children and young people's rights are being respected and protected. So I think sometimes it might actually be helpful for us to bring out a dignometer to help us assess whether or not the rights of children in conflict with the law are being respected. A dignometer could really be our test as to whether or not we're on the right track of achieving the vision that we had in mind 3 months ago when we were celebrating the passage of the UNCRC bill. So how close are we to achieving this vision, and what would the dignometer say about where we are at the moment? I think I've just skipped a slide by mistake. I have, sorry. So as I've already mentioned, the UNCRC is clear that anyone under the age of 18 years old should be treated as a child. And yet numerous reports in the past year have concluded that Scotland's approach to 16 and 17-year-olds in conflict with the law is not rights respecting. You can see the selection of reports we have here that have all been published in the last 18 months, as well as a link actually to the Council of Europe standards, juvenile justice standards. And so our approach to 16 and 17-year-olds is not rights respecting. One of Together's members, Action for Children, has repeatedly raised concerns that children and young people with the highest and most complex needs seem to be vulnerable to being involved in the adult criminal justice system. Excuse me. Last summer, Kate Whiting published a report for the Children and Young People's Commissioner's Office, specifically looking at older children, those aged 16 to 17 who are in conflict with the law. The report showed that in 2018 and 19, the vast majority, actually 83%, of the 1,906 children who are aged 16 and 17 and came into contact with the justice system were dealt with in the adult justice system, in the courts, rather than at a children's hearing. The UNCRC is really clear that a separate and specialist child justice system should be established, different to those that are used for adults. A 16-year-old child with criminal justice experience is quoted in Kate's report saying, "I don't think I understood really what I'd done or the seriousness of it, or the process, or really anything about it." Another described the court process saying, "Just go in front of him, the judge, didn't get to speak to me, can't say anything. You sit down, stand up, say, have you done it? Yes, sit back down. The sooner the better, you get it over with, just take it on the chin." Where does this experience fit on the dignometer? What has this experience done to this child's sense of dignity and self-worth? It doesn't take a lawyer to understand that this is clearly not a rights respecting approach. However, it's not just Scotland's approach to 16 and 17-year-olds that isn't rights respecting. there are widespread concerns raised about younger children being brought into the adult court process. Although Scotland has the children's hearing system, 30 to 40% of children who come into contact with the formal justice system go to court. In 2017 to 18, this included a 13-year-old, a 14-year-old, 9 15-year-olds, and numerous 16 and 17-year-olds. First brought to the fore in Claire Lighthowler's study and reinforced through numerous reports that we have here, including the promise in UNICEF's rights-based analysis of the youth justice system. This has been a key theme. UNICEF themselves have raised concerns that the children's hearing system approach is currently being undermined by the appearance of children under the age of 18 within the adult justice system and courts in Scotland. And so I know court processes are something that very many of us are likely to struggle to understand, but it's clear it's so much more traumatizing and difficult to participate in for children. And it really raises the question as to whether children can even have a fair trial in an adult court. It's therefore unacceptable that children are continuing to be prosecuted in adult courts in Scotland. No child under 18 should ever be tried in an adult court. They should be treated as children and go to the children's hearing system where this is possible. This and only this is how to ensure that children in conflict with the law are treated in a way that promotes their dignity and self-worth. The UNCRC is also clear that children should only have their liberty taken away as a last resort and for the shortest period of time. And this is particularly important when a child is on remand. And yet again, the Commissioner's report from last year showed that in 2018 and 19, 161 children aged 16 and 17 were sentenced to detention in a young offenders institution. A significant number of these children have never been convicted and they're actually on remand awaiting trial. A young person who gave evidence to the Equalities and Human Rights Committee as the committee was scrutinising the UNCRC bill said, "I think there should be a law that if you're under 18, you should not get put in Parliament and put in somewhere else, because people are going to end up worse if they end up in Parliament and if they end up in secures." It's my hope that UNCRC incorporation results in that being taken forward. I don't have time to go through kind of everything that's raised in all of these reports. I mean, I could cite these reports all morning, and I won't even start on how at odds Scotland's minimum age of criminal responsibility is with a child's sense of dignity and self-worth, or even with Scotland's vision for children and young people's rights. So I just say clearly we've got a long way to go before we achieve this vision of a Scotland where the rights of all children are respected and protected all of the time, and before children in conflict with the law are treated in a way that promotes their dignity and self-worth. But despite this, I realise I'm being a bit downbeat. We should be excited rather than glum. As Bruce, our Children's Commissioner, keeps reminding us, UNCRC incorporation gives us the most powerful tool we could possibly have to support us to achieve our vision for children and young people. Like I've said, much of the power of incorporation comes from the ability it gives children and young people to challenge breaches of their rights in the court. And where law is out of step, so some of the examples I've raised already, then it can actually be challenged. But the culture change that we're all looking for won't just happen in the courts alone. We all have our role to play in making our vision a reality. It's really clear that there's a great deal of work ahead that we need to do to ensure that children in conflict with the law experience a youth justice system that upholds their rights all of the time. A youth justice system where children feel that they are treated in a way that promotes their dignity and promotes their self-worth. It's clear that areas of legislation and policy are out of step with the UNCRC. Law needs to be amended so that all children in conflict with the law, including 16 and 17-year-olds, are guaranteed protection of their rights in line with the UNCRC. The age of criminal responsibility needs to be reviewed with urgency, and I was really pleased to hear the Minister speak about that this morning. This really needs to happen to make sure that we realise Scottish Government's ambition for children and young people. We need to end the trial of children as adults. We need to make sure that children are only detained as a very last resort. We need to do everything possible to divert all children from formal justice systems. We need to make sure that children in conflict with the law are able to use the UNCRC bill as a tool to challenge breaches of their rights. Children and young people need to have access to advocacy, to independent legal advice, so that they know they have rights and they know they have a way of realising them. I know much of this work does lie with government, and I'm really hopeful after listening to the Minister that the new Youth Justice Strategy will set out a clear commitment to take this forward. However, if we're going to achieve the vision, the culture change that we're looking for, if we're going to see all children in conflict with the law being treated in a way that produces positive results on the dignometer, then like Marie Todd said in Parliament, we will all need to act to change things. We all have a role in supporting and empowering children and young people to know about and assert their rights. We all have a role in encouraging everyone around us to take a rights-based approach. We have to be brave. We have to call out when something isn't right. And we have to be generous. We have to celebrate when something's done really well. We all need to be constantly learning about children's rights. We need to be talking to children and young people and learning and understanding their experiences. We need to be empowering children and young people to inform and to influence the decisions that affect them. In a nutshell, making sure we have our own internal dignometer and doing everything we possibly can to make sure that children in conflict with the law are treated in a way that promotes their dignity and self-worth. And we all need to be holding government to account, to deliver on the promises that they have made. So throughout the next 2 days at this brilliant conference, please keep challenging yourself. Please keep thinking, what is my role in achieving this vision? It's only through every single one of us here doing what we can that we can really make that vision real. Kind of contradicting the big reading list that I've given you on the previous slide, I would like to end my presentation with a quote from a young person with experience of the justice system who gave evidence to the Equalities Committee, because I think this sums up what we need to be doing and the approach that we should be taking. This young person said, get rid of your leaflets and your booklets, go back to basics and be human, just speak to people, talk to people about what their rights are. And I think that's what we need to take from here. We need to go back to basics. We need to talk to each other. We need to be human. We need to listen to our internal dignometer. And that's the way that we're going to be able to achieve our vision for children in conflict with the law. Thank you.
Fantastic. Thank you, Juliet. If we were in person for this conference today, I think people would be on their feet at the moment, clapping and stamping their feet. That was an incredibly powerful and comprehensive presentation. And I think it really gives life to the points that the Minister was making and I was making earlier about what UNCRC incorporation really means, that it is about this transfer of power. It's about a new way of doing things. We are following in the footsteps of other countries who are further along this journey, but we are doing things in a new way, and we're developing things in Scotland. And the role that children and young people have played in the development of the framework that we're using, and the role that children and young people, many of whom are now adults, played in securing incorporation was right at the heart of what you were saying. The first Children's Commissioner, Kathleen Marshall, when she sent a note to celebrate the passing of the bill, she described incorporation as a fantastic new tool, bright, shining, and wanting to be used, and that everyone has a part to play. And I think that was a really important point for me. And so perhaps I'll start with the first question. We've got 2 or 3 questions for you, Juliet, if you don't mind staying on. We've got 10 minutes or so, but I'm really interested in what you were saying there about everyone having a part to play, and that that different of us have different roles. So the role of children and young people and kind of knowing about their rights and perhaps acting as human rights defenders, the role of civil society, the role of government, Could you elaborate a little bit more? I think one of the things is as you set out so clearly, all of the answers to all of the questions that are coming, but I'd invite you maybe to elaborate a little bit more on the kind of different roles that you see civil society, government playing.
Yeah, certainly. I mean, I think from my presentation, then I've shown a number of areas where actually law does fall short of what's required by the UN Convention on the Rights of the Child. And the only people who can change the law are government and parliament. And so I think a really important step that needs to be taken now, immediately, is a review of the extent to which law legislation meets the requirements of the UNCRC in relation to children in conflict with the law. We need to really draw from the report that your office did on 16 and 17-year-olds and make sure that government makes the amendments that are needed to ensure that all children under the age of 18 have the legal protections that are needed to fulfill their rights under the UNCRC. And that is absolutely essential. That's like step one, that we really want to see governments commit to that, and parliamentarians seeing that through. I think when it comes to public bodies, so when it comes to local authorities, when it comes to the police, when it comes to the Scottish Prison Services, they have an obligation to make sure that their staff are trained and know about how to implement a rights-based approach. And I think that's where the UNCRC bill is really powerful, because if even if the law aligns with the UNCRC, if government or government bodies don't actually implement it in a way that's consistent with the UNCRC, children and young people can complain to the courts. They can be held to account. So public bodies need to do absolutely everything that they do, everything that they can to ensure that that they are complying with the UNCRC and progressively realising the rights of children in conflict with the law. The role of civil society, so the role of Together and our members, I'd say academics, anybody who isn't a duty bearer under the UNCRC, it's our role to hold government to account, to shout out when things aren't consistent with the UNCRC, to listen to children and young people, to talk to children and young people, empower children and young people to hold government to account. So anyone who isn't a duty bearer has got, I think, a moral obligation. If we share this vision, we have a moral obligation to really hold government to account and make sure that we're doing everything that we can to support them implement their duties correctly. And of course, I think across the board, whether you're a duty bearer under government or whether you're part of civil society, we all have a role of raising awareness and understanding of children's rights and the power of a rights-based approach. Because like I said in my presentation, culture change doesn't happen through the courts alone. It happens through everybody welcoming and embracing and celebrating what Scotland, rights-respecting Scotland can look like.
Brilliant. Thanks so much, Jules.